fostering affiliate relationships and protecting intellectual property.
Hi everybody, and welcome to some of my personal favorite subjects, intellectual property and gambling. I'm Ana Maria Baciu. I will be moderating this panel. I'm an IP and gaming lawyer for more than 20 years now, I have to say. I'm here with Ghiurcău from Maxbet, one of the main operators in Romania. He is the chief marketing officer with Maxbet, and he will have all the answers to all your questions, if you have any. No pressure. We have Marianna Tavella, which is the chief legal officer from Ghiurcău Ventures. Thank you for doing this for us. And Marko Tomić, which is an attorney at law and partner with ASL law firm. And I will ask each of my panelists to briefly introduce themselves, and then we will right into it.
Thank you very much for the introduction. So I'm the Chief Legal Officer of Ghiurcău Ventures. We invest in startups within the iGaming industry. Obviously, intellectual property rights in tech companies is one of the most important assets. So it's very important to protect those. And this discussion will be very interesting.
Thank you, Marianna. Alex?
Very nice to be here with all of you. I'm Alex Ghiurcău, Chief Marketing Officer in Maxbet.ro, which is one of the fastest growing brands in Romania, and we stumble upon multiple compliance and legal issues that we have to tackle daily, and I'm very happy to be here to discuss them with you in this open forum.
Hi, I'm Marko Tomić, partner at AST Law in Zagreb, Croatia, also practicing and supporting large operators in Croatian market, cooperating on these topics a lot with colleagues also from all over Europe. So thank you for this opportunity.
Thank you. Marianna, your views on our subject today, mastering affiliate relationship and protecting intellectual property.
So most importantly, I would say to protect yourself from liability is to do your due diligence. The most important part, you have to, when affiliates want to put some content in, they have to make sure that the person providing the content is the owner of the intellectual property rights of such content, and therefore you need to ask for certifications of ownership or even licenses to see that they are valid. At the same time, contractually, you can avoid liability by being protected. You can add warranty protections, for example, which are statements of fact that you are the true owner of intellectual property rights about the content, and in case of breach of such warranties, companies can claim damages. So that's it's an important step of any contract, and at the same time you can back it up with indemnity clauses, which basically is a promise to reimburse in case of a breach of warranty. And I guess this is making sure that you are protected under the contract and that you do due diligence before entering into the contract.
Lawyers, once a lawyer, always a lawyer. So we will go back to Alex to tell us a little bit about the perspective of the operators in the relationship with the affiliates and with respect to IP mainly. Thank you.
Look, I think our colleague Marianna summarized it very well. We work in a very scrutinized industry, and managing your compliance and legal is paramount for operational efficiency. So this means that any step you undertake needs to be viable from a legal standpoint. And us as marketeers, we've started facing several challenges that we haven't in the past because the operations around online casinos and gambling platforms have become more complex. We generate a lot of content, social media content, ATL content. We use ambassadors, influencers, and probably the common stance for all of these activities is that they need to be regulated before they start, because otherwise they can fester into something that basically doesn't. The financial benefit that you get from a commercial activity will not offset all the legal constraints and all the penalties that you can incur if you're not within the legal perimeter.
this makes sense, at least for us. Marko?
Well, I can speak maybe from the just simply contractual perspective, how to draft these. These covenants are always the same in every contract we have. This is something that is, I would say, implied and assumed, even though it's pretty clearly stated in the agreement. No one has an issue with that until there is a breach. From my perspective, when we are negotiating this, most of the time this is like self-explanatory. It's always like, this is fine. We have a license. We are certified. This is all fine. And then people sometimes maybe omit that there are other stakeholders in this line that are impacted by this agreement, not just simply the game provider or affiliate or the operator itself, which sometimes creates problems in this way, since as Alexis said, there's so much content and you have a lot of things to keep in mind when negotiating and afterwards when actually performing this type of contract.
Thank you. I will turn back to the room and ask all of you if you have any questions before I start my questions. If there's anything that you would like the panelists to answer now or at the end of the session, it's up to you. Then I will start with mine. And I will start with, how do you think that the companies, and it's a question for all of us, for all of you to start with, how can the companies limit their liabilities, their exposure to IP infringement, and what are the strategies that you are using as a company and you are using as a lawyer or as a legal officer within the company in order to mitigate any exposure that you might have?
I might start off this from
Please
an
do.
operator's perspective. We've actually devised a plan into tackling all of these activities, and it's a three-tiered plan basically. Initially, you need to generate the rules of the game, which is through a contracted agreement. Secondly, is monitor that all the elements of the contract are being respected. And thirdly, you need to make sure that everybody in the company that is generating content and is touching the intellectual property materials is constantly trained and brought up to date with all the local jurisdiction compliance rulings. You need to know what you're doing. You need to check that the good practice is in place, and you need to educate your staff permanently because it's a constructive approach. You can't build anything long term otherwise.
Thank you. Marianna?
Well, apart from due diligence and some contractual protections which I already talked about, I think other ways of mitigating liability is having intellectual property insurance, which provides some security in terms of financials where there is such a breach. Something else that's very important is to have very strict takedown policies and enforcement policies. So the moment there's an infringing content, then that content must be taken off. So immediate action is obviously very important, and having strict and detailed policies in place helps companies protect themselves.
Thank you. Marko?
Well, when we negotiate, and most of the time we negotiate for the operators, we tend to not limit the liability for these infringements.
Of course we do.
So in this way, we try to protect our client, but also the market. And at the same time, most of the time, we also have back-to-back agreements with either, if we work with state-owned operators or stuff like that, then we try to simply duplicate those provisions that we already have with the state operator or that is imposed to us by someone from the industry, trying to just have it at the same level, because as all of us said here, this happens. This is not too often, but it happens. And then it's really important to know who has which role in this type of mitigating this incident. And especially from the removal to the replacement to later on the indemnity of these things. Because if you look at it, it's not just that someone is going to sue you for the infringement of IP rights. From our perspective and what we saw in practice, the main issue is reputational risk, which is for operators, especially if it's state-owned or something like that, then it's there is a major issue for them internally as well. So in this way, when we negotiate, this is something that it's we really stick to the just being like without limitation for those things. So it's better to do due diligence and really negotiate it well, because once it's signed, then we want to have a clean sheet when it comes to this, if it occurs.
Thank you.
I actually wanted to add something on what Marko said. There is a feel of self-regulation activity, especially in our jurisdiction, because you can't rely only on the authorities to pull you on the side whenever something is off. It's more worthwhile to invest some energy and some time into making sure you're okay on your end. And I've got a very good example of that, of how much energy you can waste if you don't do your homework properly. And I'm going to give a practical example, but I'm not going to tell you if we were the defendants in this case. There was a contract that we had with an influencer, a popular person in Romania. The contract ended, but unfortunately the contract didn't cover an archive clause, meaning that the company wasn't able to retain the materials that were posted. So 2 years down the line, when a different team of marketing was in set, they didn't know about this specific content of that contract. And 2 years down the line, that influencer came back and said, "Why are you keeping all these materials with myself on your channels? It is clearly not according to our agreement that we signed and that expired." So what happened afterwards was that instead of having this due diligence done and removing the materials at that time, the respective company had to do just a very big effort into removing all the content with that person in like 12 hours. Otherwise, they would have gone into a cease and desist, into a legal litigation around the topic, and it would have just consumed time and money simply because the initial agreement wasn't abided.
Never boring life. Marko already started answering my next questions. What other risks, it's very good, what other risks other than damages, monetary damages, do you see related to IP infringement?
Well, except the exposure for the damages itself, I think the main risk is the reputational risk, and in some cases, depending on how strict the local laws are, there is also an issue about the licensing, some kind of additional scrutiny over the operator. So, but I think the main risk is the reputational risk, which is once you have something like this and you don't react properly, you don't mitigate it, because it can happen. It doesn't have to be on purpose, stuff like that, but it's really important how you manage this type of crisis, how you communicate, how fast are you in removing it, and then also in this way, I think this risk, except just the infringement and the damages, I think the reputational risk is the biggest exposure in this way.
And it probably applies to a B2B and B2C level as well.
Yes, for sure.
How do you see the obligations of the service provider to address any IP infringements? Because I think we've all seen them in practice. How do you negotiate this in the agreement, and how do you put this to life when it's happening?
So obviously having contracts in place is important, because if you lay everything down in a contract, you know each person's obligations and liabilities, and obviously as a lawyer, contracts are important. So you can include detailed provisions as to what happens in case there's a breach. You need to put obligations on the affiliates, specifically saying they have to monitor the content, they have to be able to notify immediately when they see an infringement, take actions immediately. You can even put obligations of indemnity, as discussed before, where they are forced to cover such breaches. And even you can even put obligations as to who would handle such a claim, because if there is an infringement of IP, it could be the case that the operator would like to handle the claim directly, as the reputation of the operator is at risk. So having all this in place and clear guidelines is super important.
Great. Yes, I mean, you have to agree on the procedure if it happens, and then you also have to agree on the procedure how to handle the court case. So most of the time when we are negotiating and when actual operators and people from the management and with the expertise, they are most of the time negotiating in which time frame you will react. And this is sometimes, for me, it was surprising at the beginning that people were really negotiating the speed of action. So are you going to do it in the next 15 minutes, in 1 hour, 3 hours? And yes, you would agree penalties as well for depending on how fast are you in mitigating the risk and solving it. And when it comes to potential lawsuits and stuff like that, we usually negotiate. Most of our clients do not appreciate affiliates actually litigating on their behalf. So being like, yes, we will hold you harmless and indemnify you. No, those things do not. We do not negotiate them in that way. Most of the time, we do negotiate. If they wish to do so, they are obliged to inform us in advance. And most of our clients retain the right to actually appoint lawyers who will represent the affiliate in this type of litigations or negotiations or any type of alternative dispute resolutions. So they do not tend to leave it to case and to hope like you will hold me harmless and I will be fine after you solve it because we contracted this. So they wish to participate, in my opinion.
Alex, real life?
Real life is you're looking simply at the financial implications of this activity and really at the way your operational flow is affected by any circumvention of this type. Generally speaking, you need to look at the financial considerations and the reputational risks that you are putting at risk at any time when you're in an infringement.
It seems like serious. Has any of you seen any litigation on these types of things, or are they just solved between the parties?
We've seen in operators specifically, we've seen that they are amicably resolved between affiliates and operators between them, affiliates between them, and so on and so forth. You don't really get to litigation because nobody has the time and money for that, and it's usually set down at the round table.
Yeah, because we've seen infringements, we've seen litigation, but not between operators and service providers, as between operators that are somehow infringing each other.
Well, most of the time depends on the laws of the country. So if you have to seek protection from the court, like at some type of interim measure, cease and desist, most of the time, if you are already reaching for that, all of the affiliates and the operators react on that. But then, again, you have the other set of problems you need to solve. We haven't had litigations because whenever we had a situation that there was some kind of infringement or potential infringement, that we will be only notified by third party that this might be infringing, we would react in some way just to prevent any harm. We would ask for the game to be taken down or for additional proof from the affiliate before going further. But of course, as we already know, in the contracts this is considered a breach, so it's a big risk for the affiliate and the game providers to lose a whole contract for something like that. So most of the time people are really keen to solve this amicably and fast.
I take it is the same with you.
Yes, totally. I'm not a litigation lawyer myself, so I always find the best commercial solution is to negotiate outside of court because it's in the best interest of all parties. Affiliates and operators want to work together. They have some common interests, so obviously if they collaborate to find a solution outside of court, it's always better for everyone.
I know the time is
And
up, but
cheaper.
I do have one question that I would like to ask, and this is, how do you treat, and especially you, but also Marko and Marianna, if they've seen it in practice, how do you treat the situation when the players are actually venting on the platform that the affiliates are making available? It's this IP infringement, but not only. And how do we treat this in practice?
A very good question, because it's a part of our day-by-day life in the casino. Across time, affiliates have become a very, very solid voice and a very solid acquisition channel in our funnel. So they always had the privilege of displaying brands at their own will for their financial gain, but this comes with a responsibility as well, which means that they need to be somewhat in the role of moderators, because anytime somebody complains on their platform about a third party being an operator, that can be treated as intellectual property infringement, because they are allowing this to happen. And again, we were coming back to the work frame, where every operator should keep affiliates accountable for their end of responsibility. Because if I may have this analogy allowed, it's very fun when we all share the slices of the cake, but it's usually the operators who do the dishes at the end. So this somewhat needs to be balanced more, and if the operators can have a very clear content regulation, like guidelines on how their brand needs to be treated by an affiliate, then this legal responsibility will definitely put some weight on the affiliate's shoulders, and I think their content management the quality of their content management is going to increase eventually.
This makes sense. Thank you.
I think what is very important is that when players vent on affiliate sites, operators should try and address such concerns through official channels. So take it out of, remove the reliance on the affiliate and actually address concerns of players directly, which of course improves the reputation of operators. At the same time, the burden should be on affiliates who should monitor content that is uploaded and understand whether this is defamatory content, whether this content should be removed because it tries to harm the operator. So constant monitoring of such comments should be a first priority.
Thank you.
I agree. It's just that from my experience, operators really love their players. So it really depends on the gravity and everything. We had these situations, and it was actually addressed basically directly to the players, that they were contacted by someone from the marketing department or sales department, and first asking them kindly to stop what they're doing, and then after that, of course, most of the time we had only account suspensions. In this way, just the player would be excluded. So.
Thank you very much. Please join me in thanking our speakers today, and thank you all for being here.
Thank you.
Thank you.
Thank you.